Hi, I'm Gary Nitzkin. I'm an attorney here with Credit Repair Lawyers of America. In today's short video, I'd like to discuss what's a scheduling order. Just so happens I have one here. Let's talk about a few of the highlights. Witness list. A witness list is a list of witnesses, as the name suggests, of who I'm going to call at trial and who my opposing counsel is going to call at trial. Courts like to have these lists exchanged between counsel well in advance of trial. This way there are no surprises on either side. You should note that the whole point of a scheduling order, or one of the major purposes of a scheduling order, is to avoid something called trial by ambush. I want to know what the other side's going to say before trial, and they're going to want to know what I say before trial. It allows each of us to evaluate the case and hopefully reach a settlement well in advance of trial. Another item on the scheduling order is called the exhibit list. This is a list of documents or exhibits that I intend to introduce, and of course my opposing counsel has to prepare one as well, and we exchange that too. Let's talk about the all-important fact discovery cutoff date. This is really important. This is where each side gets to find out about the other's case before trial. We use tools such as depositions, where we get to question witnesses live and under oath. We also use written documents, such as interrogatories, which are written questions that I might provide to the other party for them to answer under oath. We can also use another document called requests for admissions, where we each get to ask the other side to admit certain facts in the case. And finally, we get to use something called document productions, or requests for production of documents. This is where we ask each other, what documents do you intend to introduce? With these tools, we should both be very well prepared before trial. There's sometimes a final pre-trial date and a settlement conference date. At the settlement conference, both parties, or all parties if there's more than two, show up at the judge's chambers on a predetermined date with our clients, and we try and settle the case. If it's a jury trial, the judge can get pretty involved in trying to settle the case. The judge will beat up the plaintiff and tell us that our case is not good, and then he'll go into the other side where he'll go into another room where the defendants are and explain to them why they're going to get creamed at trial. And if he beats me up enough and beats up the other side enough where we can meet somewhere in the middle, the judge will have settled the case for that amount. Finally, there's the trial date. Now in this case, the trial date is about a year in advance. The court likes to have a trial date scheduled because it allows us to plan our schedules and allows us to notify our clients well in advance. So there are very few excuses for a party not showing up for trial. If you have any questions regarding your scheduling order or any aspects of your case, or if you have any questions about credit repair in general, call me, Gary Nitzkin, at Credit Repair Lawyers of America. The call is free, the advice is priceless. Thank you.